All right, so from your perspective, what are the most significant threats to the judiciary in this moment?
Well, as we've been hearing at the conference today, we have both the actual physical threats, the lethal threats. We've heard a lot about that, which is really astounding, to judges themselves, to their family members. But I think it's more than that. It's to the process itself. It's to the judiciary. A number of the speakers today indicated that the public does not often understand what the role of a judge is. And although our focus with this administration, this presidency, is on the federal judges, it really affects judges at all levels, state courts and federal courts. But something that I haven't heard much about today, and maybe I will later, is the dissing, if you will, of the federal court judges, the lowest court judges, by the Supreme Court itself. This is really unbelievable, unprecedented, like so many things, that in the decisions themselves, as well as remarks some of the justices have made at conferences, who do you think you are, federal judges, with a national injunction making decisions? And they're aided by the president himself and members of his cabinet, including J.D. Vance, a Yale Law graduate, who says, what do you mean, judge, telling us what to do? One of our speakers just now alluded to Pam Bondi, who fortunately is dismissed as the Attorney General, although I don't have much hope for her successor, and telling the courts to stay out of our business. The executive telling the judiciary to stay out of our business. So this, again, you've got at the highest levels of the executive branch and the highest court itself, which for many reasons I find to be an illegitimate institution at this point, calling out the justices. It's not the public, just the public at large. They are aided and abetted by this kind of rhetoric.
What role or perhaps obligation do you think the legal profession has writ large to speak up and actively advocate for the rule of law in their communities?
Well, some of this is articulated in the model rules of professional conduct, and most states have either adopted them wholesale or they have some variation on it. And this is something I'm writing about actually for the Washington Law Review, which will come out later this year, about some language that's in those rules, because and part of the preamble in particular talks about the need to further the understanding of the public of the rule of law, and to call out when decisions by public officials are not correct. I think they use the term rectitude. There's another a preambular paragraph about looking to the approbation of one's peers. And these are all important ways to inform one's work, because as it's made clear in the rules, there's some language in the rules themselves, maybe in some commentary that says it's not just about serving your client. You have a role also as an attorney to promote the rule of law to the profession itself. You know, we use the term often, officer of the court. Don't really know exactly what that means, but I think it very much means in this case, looking beyond your own client and being responsible to speak directly to the public, to speak to your peers, to get local and state bar associations involved, to have an audience where you can. Something the panelists spoke about earlier today is the role of judges themselves doing it, and lawyers being able to speak where sitting judges cannot, because they're much more restrained in terms of what they can do. And this way we can have the lawyers being the voice. And I believe that every attorney, besides pro bono obligations, and this may be a pro bono obligation, is to take on that speaking role.
Looking ahead for the next 2 years, let's say, what are the most important steps that members of the legal profession can take to strengthen public confidence in our courts and our legal system?
I know this is a provocative idea, but I think even sitting judges can find ways to speak out at conferences. Famously, last year, a number of federal judges spoke off the record to the New York Times, and that was hugely important to indicate what discontent there was among lower court judges. There are ways to get that word out there, and lawyers need to be helping that with other civics educators, because as many know, lawyers don't always speak clearly in language the public understands. That has to be a constant kind of thing, and I think law schools, as I say, are a great place to make that, to have the future lawyers hone that particular skill. And the law schools themselves need to be in the vanguard, I think, of making that happen. Because the other thing, for people who say, oh, the midterms come around or there'll be a new election, that's not going to quickly turn over where we are now. It's going to take us a while to build back what we've lost and build back better, hopefully. No, not borrowing necessarily there any particular political slogan, but it's not like this just all gets erased overnight. Tremendous damage is being done right now by this presidency and by this Supreme Court. And so we just can't let go of it. It has to be a constant refrain, it seems to me, of everyone in the profession, from private attorneys, public attorneys, law school leadership, professors, and so forth. Is just hammering home the importance of these kinds of principles we're talking about and making sure that they come back, get restored.